So my legal update today is talking about a law that was recently passed in Wisconsin that governs real estate wholesalers. So as most of you know, I'm licensed to practice law in both Arizona and Wisconsin. And when we first started this show about 2 years ago now, I think, one of our first show topics was a law that was passed in Arizona requiring that real estate wholesalers make certain disclosures to sellers and assignees within their documents. Well, Wisconsin recently has passed a very similar law. So I'm almost having kind of a deja vu moment here of going through this Wisconsin law because it really is very similar to Arizona's. It's not identical, but it's similar. The Wisconsin law went in effect in March of this year. So every wholesaler here in Wisconsin who is going to be entering into contracts with owners of residential property must have certain language in their purchase agreement. So let's break down this new law a little bit. So basically, the law applies to real estate wholesalers who intend to assign their rights under a purchase agreement for residential property to a third party. Well, the definition of a wholesaler is somebody who intends to or will assign their rights. And so if you're a wholesaler, if your intention is to assign your purchase agreement for residential property to a third party, you have to make disclosures under this law. So what is residential property? This is a little bit of a difference, I believe, between the Arizona and Wisconsin law. Wisconsin goes up to 4 dwelling units. So a fourplex qualifies as a residential property here in Wisconsin. So a property that contains either 1 and up to 4 dwelling units will qualify as a residential property. Additionally, a purchase agreement includes basically any type of interest that an investor is taking in a property. So that includes a executory contract or a purchase agreement, a lease. So if the investor is going to enter into a lease and they intend to assign that lease, then that would qualify as a purchase agreement that requires certain disclosures. An option to purchase, which again would require the disclosure. So basically, if there's any chance that an investor is going to enter into any type of purchase contract or purchase agreement, a lease, an option, and they're going to assign their interests under those documents, then they have to have these required disclosures. So what are the required disclosures? Basically, the required disclosures provide that the buyer, the wholesale buyer, must disclose to the seller that they are a real property wholesaler. That's the language. The buyer must disclose that they're the real property wholesaler. They can also take it a step further and say, buyer is a real property wholesaler who intends to assign their interest under this contract or agreement to a third party. That way, the seller, is even further informed of what it means to be a real property wholesaler. While the statute only requires the disclosure of a real property wholesaler, in my view, that doesn't really tell the seller anything if the seller is unfamiliar with what that term means. In the investment community, we understand what that means, but a seller may not understand that. So I recommend taking it a step further and just saying, buyer is a real estate property wholesaler who intends to assign their interest in this contract to a third party. The second thing that must be disclosed is the fact that the wholesaler who is now under contract with the seller does not have actual title to the property, and that must be disclosed to a third-party assignee of the purchase agreement. So basically, they have to disclose before entering, either at the time or before entering into the assignment, they must disclose to the assignee that the real property wholesaler's rights as buyer under a purchase agreement strike that. Basically, they have to disclose to the assignee that the assignor is a real property wholesaler. So there it is, that language again. So the assignor is a real property wholesaler that holds an equitable interest in the residential real property as a buyer under the purchase agreement, and that the assigner is conveying the assigner's interest in the purchase agreement and not title to the residential real property. So basically, they have to say, hey, look, I'm a real estate wholesaler. I am not on title to this, and I'm only assigning the purchase agreement. I don't have the ability to convey title. And basically, so the assignee fully understands or appreciates that, the closing is conditioned upon the seller actually performing under the purchase agreement. So, the buyer, the assignor, can't unilaterally perform. It's going to require some type of cooperation or performance by the seller in order for the assignee / end buyer to end up with title to the property. So what are the penalties for not complying with the statute? So very similar to Arizona. If the disclosure is not timely made to the seller, then the seller at any time before closing may cancel the purchase agreement and retain any deposits, any earnest money. If the disclosure is not timely made to an assignee, the assignee at any time before closing can rescind the assignment and receive a return of their deposit or any other amounts that they've paid. So basically, the penalties for not disclosing are that the seller has a right to cancel and retain the deposit, and the assignee has a right to cancel the assignment and receive a return of any deposits or other amounts paid. However, the statute does make clear that the seller and the assignee cannot waive their rights to this disclosure language. So if you realize, oh, shoot, I didn't disclose, you can't say, oh, well, here, sign a waiver of your rights. You can't do any of that. They can't waive their rights prior to closing. However, it does explain that if it closes, if the transaction closes, if escrow closes, then the right to rescind is terminated. So it's a done deal. There's no going back, a day after, a week after, 6 months after closing and saying, oh, you never disclosed to me that you were a real estate wholesaler. And now I want out of this transaction. No, if it closes, it closes, and there's no further rights of rescission. That's the statute. Those are the penalties. I think there's a little bit of confusion out there as far as, and I've seen some videos and heard some, non-attorneys out there in the space who have said, well, it's in Wisconsin, it's a crime with a $5,000 fine and punishable by, potentially up to 6 months in jail. That's not accurate. That results from a wrong reading of the legislation. So there were, as with most legislation, this was just, a tack on part of the overall legislation that dealt with real estate licensing laws and brokers and disclosures to be made by brokers of, problems with the property and that type of thing. And basically within that, they did amend the criminal penalties for engaging in the unlicensed practice of acting as a real estate broker in Wisconsin. And so they did change that from $1,000 fine to a $5,000 fine, but they left the potential 6 months in jail in place. And while it's there in the Senate bill, it's in two separate sections and is not part of the real estate wholesaler provision. So the real estate wholesaler disclosure provisions only have two penalties or main penalties, which is rescission by either the seller or the assignee if the disclosure is not made.